Good morning, ladies and gentlemen. Welcome to the People Processes Podcast. I'm your host, Rhamy Alejeal, and today we're going to be talking about leaves, medical leaves, family leaves, all kinds of leaves. So let me start out with a pattern I see pretty constantly. A business owner tells me we're under 50 employees, FMLA doesn't apply to us, and they're right about FMLA. That's the Family Medical Leave Act. But what they don't know is that their state has its own leave laws that kicks in at 15 employees. Or 10, or 5, or in some cases, 1 employee. I talked to an HR person last week who got thrown into a leave management at a company with over 300 active leave cases. She had no training, no systems, no process. A spreadsheet and a prayer is what she had. Here's what most employers don't realize. Leave management is now the #1 compliance trap for growing businesses. It's worse than payroll. It's worse than I-9s because when you get leave wrong, it's not a fine. It's an individual lawsuit with compensatory and punitive damages. The average FMLA retaliation verdict is $150,000 to $300,000. And in most cases, the violation was caused by a manager who didn't even know they were breaking the law. So today, I want to walk you through our kind of 5-step leave audit, what we do with our clients to figure out where they're at. And it'll help you figure out what you actually owe, fix your policies, and train your managers before they cost you $250,000. So, why is leave management so much harder than people think? It's because it's not one law. It's a patchwork that gets more complex every year. First, there's the federal level. Federal has the Family Medical Leave Act. We all know this one, or most people do. It's 12 weeks of unpaid leave for employers with 50-plus employees within a 75-mile radius. Your work-from-home people are considered one radius. So if you have 50 people working from home, even if they're all over, you fall under this. Most people are aware of that. Second, on the federal ADA, the American with Disabilities Act, that's reasonable accommodations, which can include leave, and it applies to employers with 15-plus employees. Then there's the Pregnant Workers Fairness Act, the PWFA. That was passed in 2023, guys. It requires accommodation for pregnancy-related conditions. It applies to 15-plus employees. And the EEOC just released their top 5 enforcement trends for this. And it's all about the PWFA because it's new and people aren't doing it right. That's 3 federal laws, 3 different triggers, 3 different requirements, and most companies have a handbook that only mentions the FMLA. I also see lots of small companies with 10 employees putting FMLA paragraphs in their handbook. If you put it in your handbook, if you communicate it that you're going to do it, you have to do it. So check that. And I'm telling you, almost every small business handbook, because they copy it off the internet, has that in there. Stop it. All right. That's the federal side. That's the easy bit. Then it gets wild at the state layer. State mandated paid family and medical leave, just like FMLA, sometimes paid, sometimes unpaid, are expanding rapidly. California, New York, New Jersey, Washington, Massachusetts, Connecticut, Oregon, Colorado, Maryland, Delaware, Maine, and Minnesota. If you have even 1 employee in one of those states, you have obligations you may not know about. Separate from the paid family medical leave is state sick laws. Even more states mandate paid sick leave with different accrual rates, usage rules, and carryover requirements. And perhaps most importantly in this discussion is, when you provide sick leave, then you have to allow people to take it when they're sick, right? And every state has its rules on what that means. Does it count when their wife is sick or their kid is sick? That all matters. Many states have what they call mini FMLA, and they kick in at even lower employee thresholds. California, 5 employees, and basically you're an FMLA company. DC, 1 employee. Oregon, 25. Let me give you a New York example. New York has a paid family leave program. It applies to every private employer with 1 or more employees. It's 12 weeks, and they get 67% of their wages, up to $1,228 a week in 2026. And as of January 25, New York added paid parental leave, 20 hours a year, first state in the country to do it. So if you hired 1 person in New York last year and didn't know about paid family leave or parental leave, you've been out of compliance since day 1. And those are things that require you pay the state so that they can pay out to those employees that 67%. There's an insurance requirement. Or you could buy private insurance to do it. Or you can submit a bond showing you have $200,000 in the bank. It's complicated. That's just New York. Let me contrast that to Texas. Texas has basically no state leave law, no paid family leave, no paid sick leave. Austin, Dallas, and San Antonio all tried to pass paid sick leave ordinances in the city, and the state blocked them in 2023. So if you're a multi-state employer with people in Texas and New York, you're operating under completely different rules, and you need policies for both. The interaction problem. The part that makes leave management genuinely complex is that these laws overlap. One employee's absence can trigger FMLA, and if it's due to disability, it could be triggering ADA. State paid leave laws, even, that they have additional leave entitlements under that, and state sick leave, right? So that you have to pay them out. Running the wrong leave or failing to run all applicable leaves concurrently is itself a violation and could wind up costing you more. If you don't document it correctly, you could wind up having to pay them back to back to back rather than them all running concurrently. If an employee says to you, I need surgery, is that FMLA? Is that Disabilities Act? Is that just paid leave? Is it workers' comp if it's work-related? The answer might be all of them, and your obligations are different under each one. Let's give the worst case, California, or the best case, depending on how you feel. An employee tells you she's pregnant. Here's what you're looking at. Pregnancy disability leave. They have a standalone for that. That covers for up to 4 months if they're medically disabled. That's paid through the state, and you pay a tax to cover it. Then there's the CFRA, the California Family Rights Act. That adds 12 weeks to bond with the baby, up to. And she can file for paid family leave benefits through the state for 8 weeks of wage replacement separate from that. Then stack it all up, and you could be looking at 7 months or more of protected leave. Okay, if you can run a lot of them concurrently, so it doesn't wind up going that long, but easily 4 or 5 months. California has over 18 distinct leave types that employers have to navigate. That includes bereavement, reproductive loss, kin care, crime victim leave, organ donor leave. It's not one law; it's an ecosystem. So how do you get a handle on this? Okay. Managing HR in-house is overwhelming. That's why we built the People Processes Advisory System. Start with our free HR resource library. Get instant access to policies, guides, and compliance checklists. But templates are just the beginning. Run our Strategic HR Audit to scan all your key domains for your people processes. In just a few hours, we'll work through and identify your compliance gaps, and my team will generate a custom roadmap for you, meet with you, and show you exactly what to fix step by step, ready to execute. Use our toolkit to generate job profiles, deploy policies, track employee documents. You're not alone. You're backed by a 5-star expert team supporting over 10,000 employees nationwide. Be your team's secret weapon. Visit advisor.peopleprocesses.com to start your free account today. The framework we use when we audit a company's leave management. It's the kind of 5 steps. It takes us from I have no idea what we owe to we have a system. One is to map your leave obligations. You start with a map. List every state where you have employees boots on the grounds. For each state, answer, do they have paid family medical leave, paid sick leave, mini FMLA, pregnancy accommodation requirements beyond the federal? Most employers have never done this exercise. When they do, they're shocked. Wait, we have obligations in Oregon we've never heard of? Yes, you do. We can go write it up. We do it for our clients. But I often bring the chart out and then go through them state by state if we're not in an urgent situation here, because they get blown away by how much they've fallen under here. The federal baseline is that FMLA 50, ADA 15, and Paid Pregnant Workers Fairness Act at 15 as well. And then you got to put the state overlays. You can kick in at 1 employee. I have a download for you. It's at advisor.peopleprocesses.com. Link is in the description. It has a state-by-state chart that does this for you. But you have to go take it and apply that to the states where your people work. That's what's going to open your eyes up. So all the research is done. We'll talk about that a bit more later. Then you got to look at your current policies. Almost all of these laws have notice requirements. It's not enough to do it. You have to tell them that it's available to them. And what I see is most handbooks have a generic FMLA policy, whether it applies to them or not. Maybe 2 pages and nothing else. No state leave, no PWFA, no sick leave that's well-defined how it works, no bereavement, no accommodations process. So you got to check your obligations and make sure that your policies match those obligations. If you don't mention the state paid leave, the PWFA accommodation process, no accrual tracking, no FMLA policy that doesn't match current regulations, maybe you haven't written it in 10 years. There have been some changes to that. You're going to have a real problem. Even if you don't do anything wrong, not giving notice is in itself a violation. If your handbook was written before 2023, it almost certainly doesn't address the Pregnant Workers Fairness Act. That's a gap, just right there. All right, now you know your requirements and you've written down the policies. Then you need to build your leave intake process. This is the step that prevents the lawsuits. When someone says, I need time off, this should trigger a decision tree. The employer says they need time off. Your first question is why? Asked appropriately. You have to have enough information to determine which law applies. If it is their own serious health condition, that's FMLA, plus ADA, plus any state leave that applies. If it's a family member's health condition, that's FMLA, plus state paid family leave if you have that. Pregnancy-related FMLA plus PWFA plus state leave. If it's an injury, that's workers' comp plus possibly FMLA. If it's anything related to military, you got to think about this. There are military protections, FMLA's military provisions. And here's one that most people miss, by the way. If an employee needs to care for a covered service member with a serious injury or illness, FMLA gives them 26 weeks, not 12, 26. Most employers who think that they know FMLA say 12 weeks, we get 12 weeks unpaid leave. No. Military caregiver leave is more than double that. And in states like Texas with huge military population, this comes up more often than you think. Okay? So family, if they're in the military, can extend much further than you think. A lot of states have bereavement laws that you got to give people 3 days off if they're, or 5 days off if it's an immediate family member. You also need to check your own internal policies against that. All right, I'm just feeling sick. I need to go to the doctor. Cool, that's paid sick leave. Easy enough. You need a form. You need a checklist, something that forces whoever handles this to run through the possible triggers, because missing one is a major violation. And designate who handles that intake. It should not be their direct manager. They know how to change tires, and their manager knows how to run a team of people who changes tires. They're not going to go through this. That's why you need an HR department, or you need an office manager or someone who's trained on this stuff really well. All right? Step 4 is you got to talk to the managers, the guys in charge, the gals in charge. This is the most important step, period. Managers cause the leave lawsuits more than any other source. The number one FMLA violation is what's called interference. A manager saying you can't take that time, or are you sure you need that much time off, or we really need you here, subtly punishing someone for trying to take time off. The other side of interference is retaliation. That's the second most common. That's a negative performance review after leave, reducing their hours, passing over for promotion. Your manager doesn't have to say, I'm punishing you for taking FMLA. They're not. They just have to punish them. And in court, timing is everything. Negative actions within 3 to 6 months of leave, you had a baby, you've been off for 14 weeks, 16 weeks, whatever. You come back and now you're struggling, and 3 months later you're firing them. The jury connects the dots, man. They say, look, you got to give them more time. What managers need to know: don't ask about medical details, don't discourage the leave, and don't change anything about the employee's role during or after the leave. And call HR immediately when someone mentions needing time off for health reasons, for serious health reasons. Give them one rule. If someone says, I need time off for health reasons, your only job is to say, let's get you connected with HR, and stop talking. That will fix it if you got an HR department. If you don't, if it's a small business, the 10 of you, you got to just remember this is a problem. If you do the work to put this stuff in policy and to research what you have, anybody can figure it out. It's not that dang crazy, but most people don't even try, and then they put themselves in a bad situation. A big part of leave is what's called the interactive process. For relief requests, especially ADA-related ones, PWFA, you got to document when it was received, what was discussed, which laws were triggered, what leave was designated, and what accommodations were offered. Every accommodation request, you got to document the process you took, what the employee requested, what you considered, what you offered, and why you chose that option. Leave has to be documented that you went through this process. If you need a deep dive on ADA or PWFA in the iterative process, let me know. I'd be happy to do an episode on that. If it's not documented, it didn't happen. And in a leave lawsuit, the employer has the burden of proof. If you don't write down that they requested this, you considered it, you considered these alternatives, you chose this thing because of this, then you didn't do it, even if you thought all that stuff in your head. Okay? And it's a requirement that you iterate, that you interact with the person and discuss with them what needs to happen. Okay? That HR person I mentioned at the top of the episode, 300 active leave cases on a spreadsheet, that is not a system. That is a disaster waiting to happen. So let's talk about kind of implementation steps so you can do this without losing your mind. You don't have to do this all at once. Here's kind of a, quarter-long plan. Number 1 is map your obligations and audit your handbook, right? This is research, no changes yet. Just understand where you stand. Month 2, build your leave intake form and a decision tree. You can use the description in the download for today's episodes. Customize it for your states and your company. Number 3, train your managers and set up your documentation system. The manager training is a 30-minute session, one meeting. It's a meeting that prevents the $150,000 verdict. It's so worth doing. And make sure it's part of your new manager training so that going forward, they're all taken care of. 90 days, 5 steps. And you've gone from, I hope we're doing this right, to I know what we have to do and we have a system for handling it. All right. Expertise for the crazy cases is going to be needed, but you can cover most of this and get rid of 80% of the dumb errors with this little bit of help. So start with step 1 this week. Go look up your state's leave laws. Takes 30 minutes, and I promise you'll find something you didn't know about. All right. I've put together a leave law compliance kit. It's in the description below. It's got the state-by-state leave obligations chart, shows you exactly what kicks in at what employee count, a leave request intake form template, a manager quick reference card for handling those leave conversations, and a 90-day implementation checklist. Download it and start with the state chart. Super easy. You can go to advisor.peopleprocesses.com. You sign up on there. It's free. It shows the episode. You can download this. It has all our prior episodes and all of our prior downloadables. And we'll email you when we have a new episode. That's the downside. I hope you enjoy those, and I hope you actually look out for my emails. We put a lot of effort into them. If your leave policy has gaps, your overall HR probably does too. I would love to offer to do your strategic HR audit. It's normally $1,000 to $4,000, but we will do it completely free for the first 10 companies after each episode. So if you go to advisor.peopleprocesses.com and sign up for that free account, you can download this checklist, but in the top left, navigate to audits and select the strategic HR audit and enter the code EP71audit, Echo Papa 71 audit at checkout. First 10 companies with 10 or more employees in the United States, we do the strategic audit for free. Okay. That's our kind of constantly giving back to the community kind of thing. In the US, okay, every episode I get somebody in, it's been all over the world. Like, can you help me with my strategic audit? It's like, man, I don't know Indonesian law. I can't help you with that. Okay. Some other episodes to check out. Episode 68 covers the full strategic HR audit, including leave management is one of those 18 domains. It kind of covers you what we're doing there. Episode 69 is about summer hiring. It's about teen employees that have their own leave and scheduling rules you need to know about. If you haven't checked it out, it's a good little episode. My name is Rhamy Alejeal. I'm the CEO of People Processes, and leave management is complex, but it doesn't have to be chaotic. It can be systemized. Get your system in place now before a manager says the wrong thing and it costs you $250,000. Now, don't HR alone. Go out there, have a great day, and get your work done, and I'll see you soon. Thanks.